Welcome to the Legal Financial Planning for Alzheimer's Patients and Their Families. Today is March 24th, 2020. Hello, my name is Douglas Chu. I'm an elder law attorney, and I regularly give these educational talks for Care in Kind. Due to the current medical emergency, Care in Kind has asked me to record this talk so that you may attend this talk from the safety of your home. Today's talk will last about an hour and will follow the written outline and materials provided to you from Care in Kind. In particular, you should have my outline, which is on my letterhead from my law office. And you should also have the actual power of attorney form, a copy of the healthcare proxy, and there will be other materials in your packet that you can read on your own at another time. So let's get started with my outline. So today we're going to be talking about the things you need to know when dealing with legal and financial issues surrounding a family member who has Alzheimer's. Or, of course, there are other disabilities that this can apply to. So we're going to follow my outline. You'll see my outline deals with three or four specific topics we're going to deal with. So you can just kind of read along and listen, and then we will actually go through healthcare proxy, power of attorney, and we will conclude with a introduction to Medicaid eligibility, which is the main way of paying for long-term care. So item number one, why plan for long-term care illness? Well, no one ever thinks about these types of things when they come to see me as an elder law attorney. People think they're going to live forever, they're never going to get sick. And mainly, they often worry more about having a will, which deals with, the end. But many things can happen to you before you become ill. And I'm sure many of you are familiar with this, having a family member who has Alzheimer's. But the explanation I give to clients and their families is that no one wants to lose control over their life, their money, what's going to happen. And by doing some of the things we're going to discuss today, it can help you maintain control of your life and your money. Basically, without these documents we're going to be discussing, one can have dire consequences for healthcare and for dealing with their financial costs. Also, having these documents is a way of doing estate planning. Without these documents, sometimes you will not be able to access accounts, IRAs, sell stocks, bonds, CDs, so on, and that can lead to a messy financial situation. So, it's very important to have these documents. I try to impress it on all my clients. Hopefully, most of them listen to me. Some of them don't, but So, okay, item number two on the outline. So what is a power of attorney? And today's class, and usually I have people ask a lot of questions, so this class may go a little fast without questions. But so what is a power of attorney and how does it work? A power of attorney is a legal document that gives somebody else your signature. It's as simple as that, all right? And you'll hear the word durable power of attorney. And there's many kinds of power of attorneys. A durable power of attorney is just what the word means. It's durable, means it survives. It will survive your incapacity. Basically, nobody should have a non-durable power of attorney. It would be very difficult to find one. It means if you didn't have durable language in there, it would mean that if you became sick and couldn't validate and confirm that you had that power of attorney and you signed that document, that it wouldn't work. And that's the whole purpose of having the power of attorney, that it can be active and you've delegated to someone else your signature. And as I say in the top of my outline there, in item two, it's like a second set of house keys. Most people say, here's a set of keys, you can get in my apartment if you can't find me, or, here's, with all my material, or here's a list of all my bank accounts and so on. So, this is a very important document that everyone has to have. Now, not only are you giving someone the signature, which is a very simple concept, is that you have the ability to move money and gift assets. And as we'll talk about Medicaid at the end, the last portion of today's class, Medicaid planning enables a person to preserve assets and make their assets last longer. However, you cannot effectuate a Medicaid plan unless someone has access to move the money around. All right. So, of course, if the person is still alert and physically able to do it themselves, that's wonderful. But as we all know, people lose capacity, and therefore, usually the family, the children, the spouse must step in, use the power of attorney to move assets around for Medicaid planning, but we'll discuss that at the end. So let's pull out the actual power of attorney and take a look at it, because today's class is also to orient you to these documents so that, if you go and see an elder law attorney, these are the things that they're going to talk to you about. And I think the origin of these classes we have at Caring Kind is to make you an educated consumer, so that when you go into see an attorney, you kind of know what they're going to talk about. You won't be in a fog. They won't have to spend a lot of time and charge you a lot of money to review what this all means, and you'll have a better idea. So if you pull out the actual power of attorney form that's in your packet, you will see that it's very complicated. It used to be in the old days, and I've been doing this for Caring Kind for like almost 30 years now. It used to be a nice one-page, double-sided document, power of attorney. However, now it becomes multiple page, 14-plus page document. And as it says in my outline, there are two parts to the power of attorney. Okay, there's part one, which is it's at the top there, power of attorney, New York State statute short form, 14 pages long. Okay, basically you're delegating your signature to someone else, and we'll go through this document in a second. And then there's a part two, which is the statutory gift rider. Okay, and the statutory gift rider deals with giving the agent that you've elected to name your power of attorney, you giving them the power to transfer money, and even if you check off the right boxes, move money to themselves. And that can be important, because if you don't do the statutory gift rider, the person is limited to only gifting or moving $500 a year, which is nothing, basically. So let's take a look at the power of attorney form. Now, this form that Caring Kind is giving you is a sample. They don't want you using this. It is advisable you see an attorney when you do one of these. Why? I mean, you can, of course, get these things off the internet. And many people come to my office and say, oh, I already have a power of attorney. And I look at it, and it's a very simple power of attorney, which I say to them, this is fine, there's no problems. But this is the type that's usually used for real estate closings and so on. But being an elder law attorney who is sensitive to the needs of older people, you will find that, or we find that there are a lot of extra things that need to be able to do, like setting up trusts, doing the Medicaid application, so on, that an elder law attorney will modify the form and make it more expansive to cover all the contingencies that might come up when you are a senior facing these medical situations. So let's look at page one. The first thing you'll see, and you can read all these words later, but I just want to point out the important things, since you have an attorney advising you right now. You must designate your agent. Okay, you can designate as many agents as you wish. Okay, you can have 1, 2, 3, 4, 5. Of course, you don't want to have too many. It can cause a lot of friction and confusion. And if you do choose more than one, the thing you have to decide, as is listed on top of page 2 of the power of attorney, is you have to make a decision whether these people, if you're doing multiple people, can act separately, or must they act together. Okay, very important. It is preferable to have people act separately, because you may have 3 children living in different parts of the country, and one lives in New York with you, and you say they can act separately. So anyone who is up to the task at that moment or available can step in and run to the bank or sign your checks or pay bills or whatever. If you say they must all act together, of course, then whatever document needs to be signed, it has to be sent to each one, and they must countersign each together to do whatever they need to do, which, as you can imagine, causes a lot of trouble. But of course, if you have to do that and you only have two people and you don't trust them individually, but you'll say they'll watch each other and not do certain things with the accounts, the bank accounts and so on, then of course you just have to do that. So that's the purpose of that, being able to designate agents separately or together. Okay, you can designate alternate agents. Okay, so you can have on the front page your son, and if your only son is not available, you can designate your sister as an alternate agent who can step in once that first person is not around. Okay. Okay, bottom of page 2, we talk about granting authority. These are all the things that you would be allowing the person to do for you. All right, continues all the way on to page 3, and we call them basically the letters A through O. Okay, you see all these little boxes. It is the advice of most attorneys that you should give all powers. So basically, we say to you, initial letter P, and you write in there, giving powers for all these matters, letters A through O above. Okay, you would write that in that space. We say that because you never know, okay, what things may come up. I have many clients who say, well, why do I have to initial claims and litigation? Or why do I have to initial tax matters or real estate transactions and things like that? I don't have those things. I say, well, you never know. Some relative may die the day before you get sick and leave you some items. And I've had many cases where the family comes in and says, oh, we have a power of attorney. And I look at it, and of course, mom has initialed all the powers except the ones we need. So therefore, it's void. It doesn't help us, okay? So, why not just initial all the powers, even if at the moment you don't really need them, okay? Letter G is modifications, and this is where an elder law attorney would put in some modifications. Also, there's a modification section in the statutory gift rider, and they will, allow more powers to be put in there. You, as a non-attorney, should not be writing things in there because you're never sure what you're allowed to do or not allowed to, because there are special rules. But this is where you'll see an attorney write certain things. Bottom of page 3, an agent can be compensated. As I tell people who are selecting their agents to be their under their power of attorney, it's a pretty much thankless job to be an agent under a power of attorney, right? You've been told you're named an agent. Suddenly, your mom, your grandma, your friend gets sick, and now you have to take off work and run over to the nursing home, run over to the hospital, go to the bank for them, and it's a lot of work. So, if it's not a family member, usually, of course, if you've chosen your son or daughter to doing these tasks out of love and affection, if it's going to be just a neighbor or a distant relative, you may want to allow them to be compensated at an hourly rate from your monies in your bank accounts. So this is the section that you would initial and put in some information about that. This next section, section H on page 4, I mentioned the statutory gift rider, part 2 of the power of attorney form. Here, if you're going to allow that person to move large sums of money over $500 or even move money to themselves, you must initial here the SGR, statutory gift rider. It must be initialed that you've done that, and then you'll see we're going to talk about the statutory gift rider in a second. These other sections we really don't use too much. Is another compensation section. Blah blah blah. Termination. Okay, termination of power of attorney. It's an interesting subject. Power of attorney, once you signed it, is active. It dies with you. Okay, this is a very common misperception. When a person dies, you can't use their power of attorney anymore. Okay, it just ends. You always have the right to revoke your power of attorney. It should be done in writing. You communicate to the agent that you're fired, basically. Okay, I don't want you anymore. I've now chosen another person, and you can revoke it. I do suggest if you are going to revoke a power of attorney, you should not only should you write the agent that you're removing the power from, but you should contact every financial institution or place that power of attorney could be used or was being used and tell them that it's been revoked. Just even verbal initially. As soon as you tell them verbally that the power of attorney has been revoked, they will freeze the account on that person. Okay, and then follow it up with a written letter. Okay, that kind of power cuts both ways. I've had people where an aunt gets angry at the nephew, calls the bank and says, he's no longer my power of attorney because they just had a fight, and then a couple of days later they make up, and of course now the power of attorney is void, and they have to do it all over again. So there's pluses and minuses to the ease of revoking a power of attorney. Okay, at the bottom of the page, gets signed and acknowledged. Power of attorney must be signed and notarized. Okay, that is often a problem. Notaries nowadays, particularly now that we're all locked in, but that has to be done. Okay, so it must be signed in front of a notary, and now next page, section N, letter N. Basically, under the current power of attorney form, the agent who you've designated must read this section and agree to take on these powers, basically saying that they know what the responsibilities are and that they'll be held liable as an agent and so on. So the agent portion, sections N and O, must be signed by the agent before they can do anything. The rule is that the agent pages 6 and 7, can be done at a future date. So if you were doing this, you would sign your power of attorney, naming your son Sam, your agent. As Sam lives in Argentina or lives in France or lives in California, you go, well, he can't be here right now. Well, that's fine. The agent can sign later on. So basically, you sign your power of attorney, you put it in the drawer, you keep it there. If you get sick and son Sam flies in from California and comes to the apartment, picks up the power of attorney, 5-10 years from now, whatever it needs to be used, all he has to do to activate it is take it to a notary, sign it, sign this pages 6 and 7, get it notarized, and that activates the power of attorney. That's as simple as that. So it's not necessary that the agent have to be here physically at the same time that the power of attorney is signed. All right, we skip ahead now, at least on my copy of page 9, which is the statutory gift rider. And if you read the opening paragraph there, it talks about that it's $500 gifting limit unless you do this and so on. There's nothing really super special here. Just know that the statutory gift rider exists. An attorney will explain this to you if you sit down with them. Here again, there's always modifications on page 10. You'll see about transferring gifts, change beneficiary designation forms, create trusts. These are all things that are necessary for Medicaid planning in particular, as we'll discuss in a while. Okay. And then on page 12, this is where a section where you say if you trust the person, that they're allowed to move things to themselves. In particular, this is important for Medicaid planning, where a spouse or a son or a daughter would be able to go to the bank and say, I need to move this money out of mom or dad's name into my name so that I can effectuate Medicaid planning or whatever other kind of planning needs to be done. But of course, this is very, can be a dangerous section of the power of attorney because, of course, you're giving the person open season carte blanche to be able to go to your bank accounts to take the money. So you do need to be wary that what power you're giving to the agent. Okay. The final thing to note about the statutory gift rider is that on pages 13 and 14, you'll see that the person must sign again this section. Okay. So they've signed the power of attorney, got notarized. They're going to sign the statutory gift rider, get it notarized, And then on top of that, because statutory gift right is so important and dangerous, that it requires 2 witnesses on the last page. So you have to find 2 disinterested witnesses to step in and witness this document, okay? So I tell clients, you do this document, you put it away in the drawer, hopefully you never need to use it, okay? And you're done. Now, there are still problems in using this power of attorney, okay? As I say to everyone, you have a durable power of attorney, and you do this one, it should be usable everywhere, and it should be honored everywhere. And I use the word should, okay? Because you may walk into one bank, say, here's my power of attorney, they go, fine, let me see your ID, fine, we honor the power of attorney. You go down the street to another bank, okay? Same day, show them the power of attorney, they go, oh, no, we don't honor that, it's not good, you need to use our power of attorney, so on and so forth. Now they're wrong, you know, or if you go to Vanguard, or you go to Merrill Lynch, or you go to, so, you know, they're all gonna have different policies. And I'll tell you that they're all wrong because there's only one policy that they're by law supposed to honor this. However, you're going to find a lot of blowback, a lot of different answers because they're worried about liability. So as it says here in my outline, that I really advise, as it says here, statutory general form, which is one we just reviewed, versus the bank's form, okay, is that, you know, while you do this one, the power of attorney we just reviewed, this is good everywhere, but if you do have money invested in a financial institution, particularly brokerage accounts, I strongly advise you contact them and say, you know, will you honor this power of attorney, or do you have your own form? And most of the big places have their own form, and they prefer you to do their own form. So since mom or dad or whoever is signing this new power of attorney, why not call and have them mail you the new form, the form from their place, like Vanguard's form or TIE Craft's form or Chase's form, and just do it. Just do it and send it back to them, put it on file. It's going to save you a lot of grief later because who wants to have to fight with them and go to their legal department and wait months for an approval of your power of attorney. Now, of course, the power of attorney you do at Vanguard or Merrill Lynch or Smith Barney or some local bank, Citibank, only works at that place, okay? And only works on the accounts designated, all right? So it's still important to do this statutory general power of attorney because this will be used in other places such as Social Security or at mom and dad's pension plan when you have to deal with them, or any other places, okay? So it is advisable to do them both, just because in real world, anyone who has experience using a power of attorney realizes that you can get, you know, bank manager one day getting a different answer from the bank manager in the afternoon in the same bank, and so on, okay? So that's a general introduction to power of attorney. And as it says in my outline, what happens if you don't have a power of attorney, okay? And this is why you have to try to push on your loved one to do one. And if they push back, you say, well, if you don't have a power of attorney and you're unable to talk to the banks or sign documents anymore, then our only recourse is a guardianship. And I have many families call me and say, well, I just want to do a guardianship over mom because she's not cooperating with this and that. Well, basically you want to avoid guardianship at all costs. We're not going to do a guardianship course right now, but you should just know that guardianship costs a lot of money. It takes a lot of time. You're talking about like 2-3 months plus having to go through the court system. Lots of rules. The court, once they appoint a guardian, will have to, guardian may have you put a bond up, okay, post a bond. Basically, everything you do has to be certified by the court. So you really totally lose control if you don't have a power of attorney. Because if you have power of attorney, basically, if you go, even if you go for guardianship, what's going to happen is the guardianship judge is going to, first thing they're going to ask is there a power of attorney? And is there a healthcare proxy already? And if you go, yes, Your Honor, there is, they go, what are you bothering the court for? Why are you coming to bother the court? You have power of attorney, you can access accounts and so on. You have healthcare proxy, you can deal with the doctors and hospitals. So why do you need guardianship? Okay. And it's just, that'll be the pushback you get from the court. Okay. So that is power of attorney. All right. I usually take questions, but we're not in that question answer kind of thing, so we can move on now. Okay, second page of my outline. How can another person make medical decisions for me when I can no longer make those medical decisions for myself? Okay. And what we're talking about there is healthcare proxies and living wills. So what is the difference between the two? All right. Well, a healthcare proxy is a legal document, and we're going to pull it out of your packet. There's a healthcare proxy form they give you in your packet. Healthcare proxy, where you designate a person to be your agent and make medical decisions for you. And we'll cover that in more detail. So what is a living will? A living will is basically a laundry list, okay, of things you want and don't want specifically. All right. The big difference between the two is one is you're appointing a person, a specific person, and then there's a whole body of laws in New York State that specifically give that person powers and what they can say, what they can do, what the document should look like, and we'll go through this form in a second. A living will, there are no laws in New York State about this. Okay, so there's no format, there's no policy, there's no enforcement. Basically, you could just turn on your computer, word processing, type up a document, take a piece of paper and write, this is my living will. I don't want resuscitation. I don't want feeding. You make a list, okay? And it's just a piece of paper. So it's in New York State, it is far more important to have a healthcare proxy designated than it is to have a living will. You can have both. I only really recommend having a living will if you have very specific, unique wishes about your healthcare that people will not normally understand. Meaning that if you believe in holistic medicine, natural herbs, you're very religious and you want all decisions to go through your rabbi, your priest, your guru, whoever it is, you want those kind of very unique wishes, you need to spell those out in a living will. Basically, a living will is an instruction manual you will give to your proxy, what the people around them, to give them guidance in making their decisions, okay? So let's look at a healthcare proxy. You have the form in front of you. You can get these off the internet. You know that every time you check into a hospital, they give you one of these forms to use. So, you know, hopefully most people are familiar with them. But if you go to your packet here, actually it's the last 2 pages is the actual healthcare proxy form. And in the front, you know, 4 or 5 pages before they're just instructions. So let's just look at a proxy form. So it's very simple. You put your name, hereby appoint a person, name, address, phone number. Now, it's important to know that you can only appoint one person to be your proxy. All right, the law in New York State is very specific. You cannot choose your 2 children, your 2 daughters, same time. You can imagine there's a conflict. If 2 people are fighting, one wants to connect, one wants to disconnect, there's a dilemma. So the law is very clear. You can only choose one, opposed to a power of attorney, as we talked about earlier. Power of attorney, you can choose multiple people, all right, which causes a problem in itself, but they've decided it's not as important as healthcare. You can choose an optional agent who can step in if that first person either resigns, dies, or whatever. So you can choose a second person here. You can put in extra information or directions. All right, you know, and basically we elder law attorneys do suggest under the law where it says optional instructions that you do write in there, and it's used to be written in here by Karen Conver. I decided not to add this anymore. But it is important that you put there that your agent, who you designated, knows your wishes about artificial hydration and nutrition, okay, feeding tube, intravenous, and so on. The law in New York State is pretty clear that unless you put in your proxy that that person has been told by you your wishes, that they will not have the authority to make decisions about artificial hydration and nutrition. So it's just important that you do write in there, my agent does know my wishes about artificial hydration. You don't have to be detailed about what those wishes are, but that you have discussed it with them and put that in there. Then at the back, you put in your name, you sign it, your address, okay? There is an optional section here about organ donation you can put in. And then you need 2 witnesses, okay? 2 disinterested witnesses. There's no notary required under a healthcare proxy. There's no notary required, unlike a power of attorney. So this is easy to do. People do multiple ones of them. Healthcare proxy, the law is that photocopies work. So once you've done one of these, you can make multiple copies and send them to your doctor, give them to your family. Everyone, if someone's really sick, you scotch tape on the refrigerator and keep important information around, and that's fine. Unlike a power of attorney, where you must have the original. A power of attorney must be the original document. So it's important that you preserve and protect the original. Photocopies of a power of attorney will not work. Photocopies of the healthcare proxy will work, okay, for a person making decisions. The final item on my outline, item 3 about healthcare proxies and wills, I mentioned about DNRs. There's not a lot to talk about DNRs. DNR is a do not resuscitate order that will be discussed with the family if someone's really terminally ill in a hospital or something. We're talking about home care, community services, so I'm not going to dwell on this too much. But an interesting note to say that if a person wants a DNR and they've gone home, like on hospice, to die, it's important that the family know that if you're home, excuse me, and you want to stay home to the end, and you have a DNR order, you cannot call 911. I have many people have these stories where a person says, "Well, I have the DNR order; it's all over the house, and but dad was in respiratory problems, and I called 911." And I said, "Well, if you do that, the EMS worker must come and resuscitate them." And they go, "Well, but there's a DNR order." I go, "They will not even stop to even look at the DNR order. They must resuscitate them, get them to the hospital, and then a doctor in the hospital will review the DNR order, and then, of course, will not do another resuscitation. But EMS in your apartment, they're coming to save you. You cannot say I have a DNR order." Okay. That's all I can say on that. Right. There's also a specialized healthcare proxy thing called the MOLST, and there may be material in your packet about that. It's a very complicated, sophisticated, lengthy healthcare proxy type program. You can look it up. I don't use it myself. It's just so complicated. It's hard enough to get the person to sign a healthcare proxy rather than go through the whole MOLST process. Okay, so we've covered power of attorney. We've covered healthcare proxies. Those are the 2 main documents a person should have in legal financial planning. Of course, a will is important. We're not covering wills today. A will is estate planning, and that's between you and your attorney. And there's not much I can really impart to you about that in this type of class. So we will now move on to the final section, which is important to financial planning, which is how do you pay for long-term care? Because you do have a loved one who has financial needs and healthcare needs, and the 2 of them can conflict, because if you don't want to run out of money, and maybe the person needs to protect as much money as possible for future expenses. So the first thing that comes to mind is people often say, "Well, I have Medicare." People don't worry if they're healthy. They go, "I have Medicare." Well, what does Medicare cover? Medicare covers many things, but it doesn't cover long-term care. All right, and long-term care is very expensive. That's the first bullet point on my outline says in item 4. 24-hour care or full-time nursing home stay can cost like up to $18,000 a month in New York City. Okay, it's just it'll just bankrupt you. All right, private home care hourly is $26 an hour. All right, so that get very expensive also. And people say, what about long-term care insurance? Well, long-term care insurance is fine. I'm not against long-term care insurance, but usually if you haven't bought it by now, it's probably too late and it's going to be too expensive. And just so you know, that when I do have come across clients who come into my office and have long-term care insurance, 9 times out of 10, it's not enough coverage, and we still put them on Medicaid because the long-term care policy is not covering enough services, and therefore we have to meld that with Medicaid to cover enough services. So, here's just a list here on the bottom of my outline that just talks about what Medicare covers, right? Part A covers hospital, Part B covers doctors. There's some skilled facility services. So if you fall down and break your ankle or break your hip, you go into a rehab facility, it covers up to 100 days, but there's a lot of out of pocket and so on. But once they've put you back together and cured you or got you as good as you're going to get back to, you're on your own, and you're not going to get services from Medicare that cover activities of daily living, bathing, cooking, cleaning, toileting, all these average everyday things you're going to need if you are incapacitated or have impairments. Okay, so where does that leave us? It's a very simple fork in the road. Okay, if Medicare is not going to cover your services, it's going to be basically either you private pay with your own money, okay, for care, for home attendant or whatever you need, and when you run out of money, you go on Medicaid, right? Or is there some way to get on Medicaid and preserve some of your money, all right? And there are ways, and that's what I'm going to cover now, a brief introduction to Medicaid eligibility, okay? You'll have my PowerPoint slideshow, Understanding Medicaid Eligibility. I'm going to just walk you through that because you need a good basic introduction, because we call Medicaid instantaneous long-term care insurance. Okay, there's basically you can become instantly eligible for long-term care insurance coverage under Medicaid. And it's important for you to know this because there's a lot of misinformation out there, and you should know that this exists. Hopefully it will relieve a lot of anxiety. Basically the services rendered, basically we call Medicaid instantaneous long-term care insurance, okay? And you'll see this for a good reason, all right? So basically, we're going to go through my PowerPoint slideshow, and there is a part, this is really an introduction course to another course run by Care in Kind, which is doing a Medicaid home care application, all right, the ins and outs of that, and I teach that also. I will be doing a tape of that program for people to listen to, since we're all locked in and can't go to classes. But if after hearing today's intro to Medicaid, you're interested in the actual application process, you can sign up for that introductory training class on Medicaid home care applications. Okay, so please pull out your slideshow, PowerPoint, and feel free to take notes on it or whatever. And I'm just going to walk you through this. It'll take me around 20 minutes, and then you'll know enough about Medicaid to see how it works and if it can help you or not. Page 1. So Medicaid services, and pardon me because the names sound the same. Medicare sounds the same as Medicaid, but they're very different. Okay, Medicare has nothing to do with money. Donald Trump has Medicare, right? So you have lots of money in the bank, and you get Medicare because you paid enough taxes over 10 years of your lifetime, and you're entitled to that. Okay? Medicaid is all about money, all right? It's what's called a means-tested government entitlement, which means they're going to look at the applicant's means of support, their monthly income and their savings. So on page 2 of the outline, I point out that Medicaid services vary from state to state. So today we're only talking about New York State rules, New York State Medicaid program. There are 50 different states. There are 50 different Medicaid programs, okay? Go across the bridge to New Jersey, it's totally different. You cannot do pretty much all the things I'm about to discuss with you over in New Jersey, all right? So it's important to stay here in New York. New York is the biggest, best, most liberal Medicaid program of all 50 states. So you're lucky if you're here. People who get sick, who are retired in Florida and Arizona, will move back here to get services because there are virtually no services in Arizona and Florida under the Medicaid program for home care. So Basically, there are two categories of services you can get under the Medicaid program. There's home care services and there's nursing home services. Today's class is only dealing with home care. All right, we'll spill a tiny bit into nursing home, but that's a whole nother thing, and you probably should have a consultation with an elder law attorney if you're considering a person going on nursing home Medicaid. There's much more complicated rules, and there are some sophisticated planning things that can be done that are beyond today's class. The first thing you need to know about Medicaid when you're considering it is that the applicant must currently need Medicaid services, okay? Unlike Medicare, where you walk around with your Medicare card in your pocketbook or your wallet, and just whenever you get sick, you pull it out and you use it. Medicaid, you can only apply for it when you are sick, okay? I have many clients call me and say, I want to get my mom on Medicaid, and I say, what's wrong with her? And they say, nothing, she's pretty good right now, but I heard it takes a while to get on Medicaid. I'd like to apply and get it all set up so in case she needs it. You can't do that, okay? They're going to question, when you apply to Medicaid, they're going to want to know what's wrong. They want to come examine mom, get proof. And then if you were to apply for Medicaid, which some people do, and then don't use it for a few months, they shut it down. They're just going to close the Medicaid application down, and it was useless to even go through that process. The final thing on this slide at the bottom of the page, basically the illness that you are suffering from that makes you want to apply for Medicaid has to be serious enough to last at least 120 days. Meaning that, mom trips and falls or breaks her foot and is hobbling around the apartment, and you say she could use an aide to help her with bathing, cooking, cleaning, toileting. If Medicaid comes and assesses, they're going to say, well, the cast is coming off in a few weeks and she's going to be okay. It's not going to last at least 120 days. You don't get Medicaid. Okay, so that's just a qualification of when to look for Medicaid services. Okay, next page. Eligibility obstacle course. So as I mentioned before, Medicaid is a means-tested government entitlement, which means that Medicaid's going to look at the income and assets of the applicant, the monthly income and the assets in the bank and whatever else they have. They will do a medical assessment, as I mentioned before, to see how much care you need and how sick you are. So that's going to be done. So as you see on the flow chart here, I have the different categories of what's going to be reviewed. One is they're going to look at income, monthly income. And if the income is above the Medicaid allowable levels, they're going to push them into the surplus income program, which I'll discuss on the next page. And they're going to look at resources in the bank or other assets you may have. And if you have too much stuff, too much money that makes you ineligible for Medicaid, we're going to discuss in the following pages, is there some way to move that money or divest those assets to make one eligible for Medicaid? And can you do that? And then finally, of course, there'll be a medical review, as I mentioned before. And you will have to choose a home care provider to determine how many hours you need. And basically, as it says at the bottom of the chart, you really need more. While Medicaid does provide general housekeeping, light housekeeping, cleaning, doing laundry, cleaning the apartment, most people will not go on Medicaid just for that, okay? It's not worth going through the rigmarole of a big Medicaid application just for the purpose of getting a housekeeper. Most people will be better off just private paying out their own pockets money to have someone come and do light housekeeping around the apartment. Okay. So income rules. Surplus income rules is called, all right? So Medicaid, which was originally designed to be for poor people, allows you to have a maximum monthly income of $875 a month, okay? That $875 is supposed to cover all of your monthly expenses, rent, food, utilities, so on and so forth, okay? Which is impossible. No one can live in anywhere on $875 a month, okay? All right? So what happens if you have more? Most people do. If you look at the right side of the page, it deals with home care. On the left, on the left side is home care. On the right side is nursing home. We'll talk about that briefly in a second. So as I just said, if you have more than $875 a month in income, Medicaid says you have surplus income, right? So and to give you an example, let's say Mrs. Smith has $1,875 a month income. She's $1,000 over. So on the far left, what happens is you have to give Medicaid all your extra income. So basically, in my example of 1875, you'd have to write a check over to Medicaid for $1,000, like a deductible, and you get to keep $875 to live on. All right, and that's impossible to live on in anywhere. So what do people do if they want to go on Medicaid? What they do is the center box. Okay, you can put your surplus income, the amount over 875, into what's called a pooled trust, or what's known as a pooled income trust. And these are charitable, not-for-profit trusts. And in your packet, I just remembered, is a list of those pooled trusts that exist out there, at least the ones that are on the list for carrying kind. And they give all the requirements, and of course, nothing's free. They do charge monthly fee and so on. You can look them up. So what happens is, mechanically, is rather than give Medicaid the extra income, okay, you put the extra income into a pooled trust every month. It's like a bank account, okay? And any money you put in a pooled trust becomes invisible to Medicaid, all right? So if you open up the pooled trust and you regularly are going to put in the surplus income, and this all has to be approved by Medicaid, because the trust has to be approved by Medicaid, and you have to prove to Medicaid that you're depositing the money in there every month, that Medicaid says, okay, you only have $875 a month available to you, therefore you're income eligible for Medicaid. And your extra income is going in the pool trust. So the question then next should be posed is, what happens to the money in the pool trust? It is still the applicant's money, okay, to spend and use for their self. But there are qualifications. There's no free lunch in the world. Number one is that the pool trust is not an ATM machine. You cannot take cash out of the pool trust, okay? You can only send bills to the pool trust to be paid. So you can send your rent bill, you can send your utility bills, you can send sometimes credit card bills with the approval of the trust, depending on what you're charging on the account. And that's how you get your money back out, okay? You cannot take it. The $875 cash you keep in your pocket from whatever you want to spend it on. But the extra money, and I have clients who have $4,000 or $5,000 monthly income, and they're putting all their extra income in the pool trust. But of course, they have higher expenses. They have rent of $3,000 a month, and they have utility bills. And some people have mortgages and so on. So the money can still be sheltered and used, and most people find this works fine, and that therefore nobody should be saying I cannot. Don't want to go on Medicaid because they're going to take all my income. Okay, you should be using a pool trust to shelter the income. Okay, all right. The other thing is people always bring up at the class is that what happens to the money when that's in the trust if the person dies. And there are rules that when the person who's on Medicaid passes away, any money left in the trust is a donation to the charity that runs the trust. That should not be really problematic because there's usually very little money in there every month. I mean, you're putting your money in there every month, you're spending most of it at the end of the month. So there's a few $100s in there, so that's not a big deal. And I think I did mention that the pool trust does charge a management fee each month, and that will be found on the chart in your packet about what they charge, and each one charges differently how they run that. The income rules, without going on to just talk nursing homes for a second. Nursing homes, basically, you cannot use a pool trust, okay? So if you convert from home care Medicaid over to nursing home Medicaid, you must stop using a pool trust. You cannot shelter or hide money in a pool trust. All your income goes to the nursing home, okay? So in my example of 1875, you get the 1875 Social Security and pension monies over to the nursing home, and then Medicaid pays the rest of the bill. So it's a good deal, actually. And since you're living in a nursing home and don't have expenses anymore, basically the nursing home will give you back $50 a month for pocket money to pay for whatever, okay? So that's how income works. It's pretty clear. Most people nowadays have a pool trust unless you have very low income, and then you don't need a pool trust, all right? Okay, next page, resources. Right? And it's important to distinguish between income and resource. Income is a monthly recurring check you receive, your pension check, your Social Security check, RMDs, required minimum distributions from your IRAs. Those are income. But assets or resources are just money sitting there or things of value sitting there that Medicaid would say, use that to pay for home care or nursing home, all right? So under the Medicaid rules, you're only allowed to keep so much money in the bank. And the limit here is $15,750. Okay. If you're $1 over that, you're not eligible for Medicaid. So when you're adding up to see what you're worth before you apply to Medicaid, there are certain exempt assets, listed here. They don't count your furniture, they don't count your jewelry, they don't count cars, they don't count prepaid funeral of unlimited amount. Okay, you want a $400,000 funeral, it's fine with Medicaid. It has to be non-refundable and paid to the nursing home, to the funeral home. They'll even let you pay for all the funerals of your entire family. It's a bizarre rule. Okay, interesting. Retirement accounts. IRAs, 401ks, and retirement-related deferred compensation accounts are exempt. The money sitting in there does not count for Medicaid eligibility. However, the rule says that that retirement account that you have, well, they're not going to count the hundreds of thousands of dollars sitting in there. It must be in monthly payout based on your life expectancy, right? Just like you all know about RMDs, when you hit a certain age, you have to start taking distributions. Medicaid says it must be set in distribution. And of course, those distributions go to the previous page and you stick it in your pooled trust every month. Okay, so you may have $500,000 in an IRA and you're taking out like $1,000 a month RMD, that goes into pooled trust, but your $500,000 in IRA is exempt and can just sit there. And when you pass away, it goes to your named beneficiaries. So that's how they deal with IRAs. Your homestead, the house, the condo, the co-op you live in is exempt. Medicaid doesn't count it. There is a maximum value. It cannot be have an equity value of more than $893,000, okay, to be exempt unless you have a spouse living in the house. But you do have to worry that while Medicaid says you need a house to live in, we're going to let you stay there, that they will have a right of recovery if the house or co-op or condo passes through the will or through your estate. So it is advisable to see an elder law attorney about what options there may be to try to preserve the house for the family and make sure Medicaid doesn't get it later on or get recovery from it. But that's beyond today's class, okay? Because there are certain people you can give your house to. We're not going to cover that today either. You can give your house to a disabled child who's been living there, or a child who's been taking care of you for a number of years. There are all these exceptions, but we leave that to having a private consultation with an elder law attorney. Final box on this page is Holocaust survivors. We don't see too many people anymore, but restitution money from Germany or Austria is exempt of the Medicaid program. So most people have more than $15,750 in the bank, okay? So what do? Next page, page 6. What about just giving away the money? So the man with the wheelbarrow has more than $15,750. So what if he just gives that money away to his wife, or to the husband, or the spouse, or to friends or family? Okay. Well, under the current Medicaid regulations, and these have been the same regulations so that I've been doing Medicaid 30 years, and it's been this way for 30 years pretty much, that if you give away your money, the following month, you are fully eligible for home care services, okay? There's no waiting period, there's no look back, there's no nothing. So many of you out there, you go, well, what about this? I've always heard the 5-year look back, the 5-year waiting period. Well, that thing does exist. However, as you see on my chart on the far right, yes, if you give money away, there is a waiting period of up to 5 years for nursing home care. There is no penalty for giving away your money for community home care services, okay? So just by moving the money, like when we're in March right now, if you move the money over to your family to hold for you, then in April, you can apply for Medicaid home care, okay? And of course, anyone you give the money to, you must alert them that, well, I might need that money back because if I need nursing home care in the next 5 years, you will probably have to return that money to me, okay? But of course, on the other hand, if you stay on home care for 5+ years and then need nursing home care, any money you have moved to the family or to whoever to hold for you is protected. And you never have to use that money for care again. And it gets kept by the family. I mean, realistically, we say the reason for asset moving is that Medicaid leaves you with so little money to live on, the $15,000 and the income of 875 or whatever it is, that you need that money from the family to help support you, to pay your rent and pay for extra things. I don't look upon it as trying to, for passing wealth on to the next generation. It's that you really need a little war chest of money to carry on and take care of you for the rest of your life, even if you're on Medicaid. Okay, so the next page, many people who come to these classes are married. You have a husband and wife situation. And this page just covers the rule when you have a husband and wife. And in some of your packets, there may be some information on spousal refusal. That is covered more in the, the Medicaid application class. But moving money from husband to wife or wife to husband is more typical if you are married. And if you move money from husband to wife or wife to husband, you do this thing called spousal refusal, which we'll cover more detail in the other class. Basically, Medicaid has a right to go after the well spouse and so on. But if one needs nursing home care, that's considered an exempt transfer. So if you move all your money from husband to wife and wife to husband, the person who has now no money now, the poor spouse, can get home care or nursing home coverage. Okay, there's no transfer penalties if you move money to your spouse for home care or nursing home. So that's typically what we would do. And the ramifications for that we will cover a little more in the other class, or you need to talk to your own attorney about that, about the liabilities on the spouse who's sitting with all the money. Okay. Finally, I'm just going to give you a brief introduction to how Medicaid works nowadays. We're on page 8 of my slides. Basically, Medicaid is managed care. It's like an HMO. Once you apply for Medicaid, you will be issued a card and a number. You then take that card and number and you go choose an MLTC home care agency. And in the home care class, we give you a list of the MLTC home care agencies out there. You choose the MLTC home care agency. You tell them, I have been approved by Medicaid, okay? And then they will come and assess you for services, and then Medicaid sends them a check to take care of your loved one, okay? Page 9 just shows what's going on behind the scenes. Basically, when you apply for Medicaid, that you need A, B, and C before you'll have actual home care in your house. You need an application, which we will cover in the other class, part 2, financial review of income and assets and pool trusts and all that. You get approval letter from them. You must do this thing called a conflict-free assessment, where they send an independent nurse to the apartment to assess your general needs. You get a letter from them, so you have your letter, you have an approval letter from A, you have an approval letter from B, then you go and choose your MLTC home care agency, okay? And the MLTC home care agency then will come and assess and put home care in place. How long will this take? Page 10. I would say it's safe to guess between 2 to 3 months from you start the process of putting an application in till you have a worker standing in the house taking care of the loved one, all right? You should anticipate about a 2 to 3 month lag. I don't know what's going to happen with today's shutdown, but let's talk about in the future the way it's going to work, all right? So that's it for today. There's a little timeline of the application process. A lot of these last 2 or 3 slides are covered more in the application class for Medicaid home care. So I won't go into it in detail right now. But so today, I hope you understand now the need for a healthcare proxy, the need for a power of attorney, and you have a general introduction to Medicaid home care. And if you feel that you'd like to learn more about the application process and how to apply and fill out an application form, you can sign up for the Medicaid home care application class. So thank you for attending today's session. Normally I'd be taking questions now, but we're not in that kind of situation. I am available if one wanted to call me or email me any general questions. I'm happy to answer general questions. If it's it starts getting too deep, I will recommend you come in for a consultation, or we'll see a consultation with any LOR attorney you wish. I know Karen Kine does do counseling and has more information on hotlines and so on, so you can address certain questions to them. So thank you for attending today's class, and that's it. Maybe hopefully I'll see you guys in the future when we're all allowed out of our houses to go to real classes. Thank you.